Milord, kindly, Milord, comes to Milord page 69. That is, Milord, the order of demolition which has been passed against me. Kindly see, Milord, may I place it? Heard the submission of all the who is passing this order. This is order is being passed by the subdivisional officer Diamond Harbour. Heard the submission of all parties present at length and minutely verified the case records. All the parties have been given opportunity of being heard by they have all failed to produce any documentary evidence in support of necessary permission from the appropriate authority regarding the alleged unauthorized construction as made in the report of the Pradhan Nalua Gram Panchayat Divide Office No such and such dated 16 July 2025 as per the West Bengal Panchayat Amendment Act 2017. Hence, considering the above facts and submission of all the parties and after going through the report of the Pradhan Nalua Gram Panchayat Divide her office memo dated such and such dated 16 July 2025, it is clear that the construction as made in serial number 12335. Milord, I am not concerned about 1235. My concern is 9, 11, 12. 5, 9, 11, 12. 1, 2, and 3, I am not concerned. 5, 9, 11, and 12, I am concerned. Are made by the petitioner, made by the petitioner, Chalamat Loskor, son of Kayamat Loskor, such and such, and the respondents, Abdul Ali Piada, that is my client, son of Akash Piada, son all residing at such and such. Number 2, Sahabuddin Dorji. Number 3, Shabir Dorji have constructed their house on LR plot number 9165, JL number 30, Mouja Nalua, PS Mathurapur, without taking any permission from Nalua Gram Panchayat as amended under subsection 1 of section 23 of the West Bengal Panchayat Act 2017. On minute verification of the case record, submissions of the concerned parties going through the proceedings of the case in detail, I am satisfied to construe that disputes construction in serial number 1, 2, 3, 5, 9, 11, and 12 over LR plot number 9165, JL number such and such, Mathurapur, without taking any prior permission of Nalua Gram Panchayat as mandated under subsection 1 of section 23 of the West Bengal Panchayat Amendment Act 2017. Now, I, in the capacity of subdivisional officer, Diamond Harbour, in exercise of power conferred upon me under subsection 5 of section 23 West Bengal Panchayat, do hereby direct Chalamat Nashkar, son of such and such, Abdul Ali Piada. This is my client, Abdul Abod Ali Piada, son of late Akash Piada, all residing at such and such, then Sahabuddin Dorji, Sabir Dorji, to remove their unauthorized construction as mentioned in serial number 1, 2, 3, 5, 9, 12 to the of the report of the Pradhan Nalua Gram Panchayat or memo number such and such dated 16 July 2025, as well as to remove the debris and other materials and LR plot number. Well, this is the demolition order which has been passed. Now, Milord, kindly comes to Milord page 67. Milord, kindly see, Milord, the order dated 30th July 2025. Page 67, Milord, the order sheets. Yes. Now, Milord, kindly see, Milord, the second, Milord, after Milord, in the middle of that page where the Milord, the attendance sheet, Milord, kindly see, on 30th July 2025, writ petitioner Chalamat Lashkar. Then after that paragraph, in course of hearing procedure, after that paragraph, in course of hearing procedure, yes, procedure, Pradhan Nalua Gram Panchayat submitted report vide memo number such and such dated, which is kept with CR and make part of the proceedings. The report is as follows. So, my lord, he is quoting the report. The HDO is quoting the report. My lord, kindly see, my lord, I am concerned with, my lord, kindly comes to page 68.5. Kindly see page 68, my lord, 5. বাসগৃহ, মাটির দেওয়াল, খড় এবং অ্যাসবেস্টাস ছাউনি. This, my lord, the SDO is directing demolition. Then Millard 51 feet by 18 feet equal to 918 square foot. পশ্চিমবঙ্গ গ্রাম পঞ্চায়েত আইনের 1973-23(5) ধারা অনুযায়ী মাটির বাড়ির ক্ষেত্রে 18 বর্গ মিটার অধিক পরিমাণ জায়গার ঘর তৈরি হলে গ্রাম পঞ্চায়েতের অনুমতি প্রয়োজন হয়। এক্ষেত্রে এবাদ আলী পিয়াদা অনুমতি নেয়নি, সুতরাং নির্মাণটি অবৈধ। Then Millard kindly see Millard 12 বাসগৃহ বাঁশের মাটির দেওয়াল অ্যাসবেস্টাসের ছাউনি 28 feet into 17 feet 476 square feet পশ্চিমবঙ্গ গ্রাম পঞ্চায়েত আইনের 1973-23(5) ধারা অনুযায়ী মাটির বাড়ির ক্ষেত্রে 18 বর্গমিটারে সেম রিজনিং হি ইজ अगेन গিভিং। অধিক পরিমাণ হইলে জায়গার ঘর তৈরি হইলে গ্রাম পঞ্চায়েতের অনুমতি প্রয়োজন। এক্ষেত্রে এবাদ আলী পিয়াদার অনুমতি নেয়নি, সুতরাং নির্মাণটি অবৈধ। Then Millard kindly see 9 again বাসগৃহ বাঁশের বেড়া অ্যাসবেস্টাস ছাউনি on the right hand side again Millard same thing। পশ্চিমবঙ্গ গ্রাম পঞ্চায়েত আইনের 23(5) ধারা অনুযায়ী বাড়ির ক্ষেত্রে 18 বর্গমিটার অধিক পরিমাণ জায়গা ঘর তৈরি হলে গ্রাম পঞ্চায়েতের অনুমতি প্রয়োজন। এক্ষেত্রে শাহাবুদ্দিনের দর্জি অনুমতি নেয়নি, সুতরাং নির্মাণটি অবৈধ। And Millard ultimately at the bottom is 11 is a গোয়াল ঘর। Millard where Millard my domestic animals Millard are kept, গোয়াল ঘর বাঁশের বেড়া অ্যাসবেস্টাস ছাউনি। Millard these are the nature of constructions. Kindly see these are the nature of constructions. Millard 28(5)(3) is being invoked. Now Millard our first point is this is the report Millard where Panchayat is filing to the SDO without Millard prior intimation to us, no copy given, no objection Millard has been permitted to be filed against this report. We are coming to know about this report Millard at the time of hearing and this order. 1. Number 2, Millard kindly Millard sees 23(5) once of the statute.
Amendment Act. 23(5) Amendment Act.
No, নতুন data.
23(5) Amendment Act, not 2017, not to 1973. 2017 Amendment Act. I do not have a book.
Now kindly see Millard 2023 subsection 2.
Subsection
2.
Yes.
It says Millard every person seeking permission, my lord has got it Millard. The permission under subsection 1 shall make an application in writing to the Gram Panchayat in such form containing such particulars and on such payment of such fees to the Gram Panchayat as may be prescribed, provided no amount whatever manner or name or manner other than the fees prescribed by the state government shall be charged by the Gram Panchayat for such permission, provided further that there shall be no restriction of covered area on construction of kacha and semi pakka residential building which shall mean a single storied building not having concrete roof and brick wall with setback not less than 1/9 meter on the roadside.
Nine-tenth meter.
New construction টা কোথায় জানো বলো? 23.
Okay. Yes.
Therefore, Millard, where there it is not required, no restriction is there. Where there is a kacha and semi-pakka residential building with a single story, which shall mean a single-storied building not having concrete roof, and brick wall with setback of not less than 1/9 meter on the roadside.
That is a space between the building and the road.
Millard, in that case, it is not required. Now, Millard, kindly see, Millard, the nature of my construction. Millard, in 5 9, 11 and 12 at page 62, Milord, it says Matir Dewal Khor asbestos e Chhauni. Matir Dewal Khor এবং asbestos e Chhauni. All the Milord same. 5, 9, 11.
বাঁশের মাটির দেওয়াল asbestos. বাঁশের বেড়া. বাঁশের বেড়া, how it is home? 9.
My lord.
9. Number 9.
বেড়া asbestos এর ছাউনি।
বাঁশের বেড়া asbestos এর ছাউনি। 5, 9, 11 and 12.
Okay.
Therefore, nothing, my lord, is concrete. Well, kindly see, provided there shall be no restriction of covered area or construction of kacha and semi-pakka residential building. I may be at best, my lord, classified as kacha, not even semi-pakka. Residential building, which shall mean a single-storied building, my lord, Goal Ghor, my lord, I do not know whether it can be at all classified as a building, my lord. I am not aware, my lord. The storied building not having concrete roof. My lord, none of the, my lord, this Nirmaner Prokriti says it has a concrete roof. None of them. It says, my lord, Matir Badir Dewal Khor ebong asbestos er Chhauni. Then, my lord, kindly see the next proviso. Next proviso, provided also that no permission under subsection 1 shall be necessary, subject to permission of a self-declaration of erection of any new thatched structure. The, my lord, here the word new is very significant. Rules done on institute. এটা চলে না
What my learned friend is referring to Act of 2013, 73 on West Bengal Panchayat Act. But the order SDO passed the order. And kindly see, Lordship, the order of the SDO passed.
My lord, these are all 2017 amendments. My learned friend is perhaps not having the book, and my lord, he is submitting.
Yes, I have.
Yes,
2016 এর book.
Yes. I have the new book only. Then, my lord, kindly see, my lord. My lord is looking at the rules, perhaps.
Payment of fees exemption. No permission from company. Yes. Next.
Then, my lord, provided also that no permission under subsection 1 shall be necessary, subject to submission of a self-declaration for erection of any thatched structure, tin shed, tile shed without brick. My lord, subject to correction, I fall under this. Brick the wall covering an area not exceeding 18 square meter, where such structure or shed does not cover more than 3/4 of total area of the land, and there is a setback of not less than 1/9 meter on the roadside. My lord, kindly see, my lord, the report of the Pradhan, my lord, and the Montobbo, my lord, which is there in the page 68. My lord, whether, my lord, these findings are there.
Whether in respect of 5.
5, my lord, everywhere. 5, 9,
No.
12, 11 and 12.
It says of without brick wall.
Without
If
brick.
it is, so বাঁশের বেড়া
বাঁশের বেড়া,
without brick wall.
brick wall.
So far as 9, 11 and 12 are concerned, it falls within, as per you, this provision. But what about 5? 5 have a দেওয়াল.
মাটির দেওয়াল।
মাটির দেওয়াল, not
মাটির
brick wall.
দেওয়াল।
মাটির দেওয়াল, mud wall, not brick wall.
This is not brick wall.
Not brick wall, মাটির দেওয়াল.
Okay.
My lord, if I may go back to the earlier proviso, if your lordship, my lord, kindly permit me to read it again. Provided further that there shall be no restriction of covered areas on construction of kacha and semi-pakka residential building, which shall mean a single storied building not having concrete roof. I'm not having a concrete roof. This is their report. And brick wall with setback of of not less than 1/9 meter of the roadside. Therefore, I don't have a one is milord mud wall, others are milord all milord beda, masher beda. Milord, this is apparent from their report only. Now, milord, kindly see milord subsection 5. Where any new structure. Milord, kindly see milord where any milord next two words is milord very important. New structure or new building. Milord, nowhere your lordship will find my constructions and new structure or new building. Building is milord far less. Milord, we are Goal Ghar and Matir Dewal. Cannot be classified as a building at all. Let us proceed. These are structures. Therefore, structure is qualified with the milord adjective new. It has to be new. Building or any addition or any structure or building is being or has been erected or made. Therefore, a building has to be erected or made. Not milord, it does not cover milord the existing constructions. As the case may be in contravention with provisions of subsection 1, the permission granting authority shall refer the matter to the subdivisional officer concerned, who shall, after giving the owner and of such building an opportunity of HUD, make the direction of demolition. This is exactly that has been done. One. Number, milord, therefore, milord, kindly comes to, milord, my amendments in the writ petition. At page 8, para 16. Kindly see, milord. The petitioner number 1, Abad Ali Piada, is responsible for construction of a residential structure made by mudwall shed having an area of 918 square feet, which is more fully described in serial number 5 of the said report. The petitioner number 1 is also responsible for residential kacha structure made with bamboo and mud wall and asbestos shed having an area of 476 square foot, which is more fully described in serial number 12 of the report. However, there is no observation in the said report whether the said constructions are new construction or old construction. The aforesaid construction are old, being constructed by the predecessor in interest of your petitioner several decades ago, and thus the construction does not fall within the mischief of section 23(5) of the West Bengal Panchayat Act 1973. I've taken a specific ground. Milord, their report, milord, itself is not clear whether they are, milord, 23(5), milord. My understanding is, milord, there has to be a new construction, and milord, there has to be which has been erected. Milord, these three are the, milord, adjectives, milord, which qualify, milord, the structure in section 23(5).
Now, who filed the writ petition in the earlier?
Chalamat Lashkar.
One of the illegal construction.
His constructions are 1, 2, and 3. I am not aggrieved by that. His constructions are 1, 2, and 3. He complained about, milord, unauthorized construction against me. His construction was also found to be illegal. 1, 2, and 3. I am not concerned with 1, 2, and 3. I am concerned about 5, 9,
11, 12.
11 and 12.
Is Chalamat not a necessary party in the writ petition?
Milord, I am challenging the report of the, milord, order of the, milord, SDO. Chalamat, milord, if he is aggrieved by 1, 2, and 3, let him come. I am not touching his construction. I did not file any writ petition that his construction is illegal. I have never went to disturb him. Milord, these are, milord, petty, milord, village issues. Milord, for Goal Ghar, milord, mud wall, milord, 23(5) has been invoked. Milord, the date of demolition, milord, has crossed, milord, on Monday. That's why my lord has given leave, milord. The police, milord, may come any day, milord, under the order of SDO, milord, and demolish, milord, a mud construction.
Yes.
Whatever the SDO acted on the basis of the report supplied by the concerned Gram Panchayat.
Hmm.
And one of the amendments, main amendments, that they were not given ample opportunity of hearing, etc. These are all false. Several dates I am placing before your lordship. The inter proceedings, different dates.
Yes, yes. I said that the report was never supplied.
You appeared before the Pradhan.
No,
No.
you have there was no proceedings before the Pradhan.
As the SDO initiated the proceedings pursuant to the direction passed by this court in a contempt rule proceedings.
We are not party, we are not aware of that.
SDO initiated the proceedings as per the direction in a contempt proceedings rule proceedings WPCRC 60 of 2019. Kindly come to page 2 of my report.
No. Which was the writ petition filed by Chalamat?
Chalamat, Miller kindly comes to Millard, page 53.
Chalamat first come approach before this court. This court directs the concerned local bodies to look into the matter.
Here also, Millard, I have a point. Kindly comes to Millard, page 53. Kindly comes to the third paragraph. According to the petitioner, my lord has got it, Millard. According to the petitioner, Nalua Gram Panchayat did not take any steps to comply with the directions passed by this court. The petitioner thereafter filed fresh representation before Nalua Gram Panchayat and its Pradhan in November 2021 and alleges that the same has not been taken up for consideration till date. Learned counsel of the private respondent submits that no unauthorized construction has been made by the private respondent. The petitioner at this stage stresses upon the communication made by the Nalua Gram Panchayat mentioning that Nalua Gram Panchayat has not provided any building plan approval plot number 9165. As it appears that the court on an earlier occasion directed Nalua Gram Panchayat to consider the representation filed by the petitioner. It was incumbent duty of the Nalua Gram Panchayat to comply with the order of the court and to consider the representation filed by the petitioner. In view of the above, the instant writ petition stand disposed of by directing respondent number 9 and 10. Respondent number 9 and 10 was Nalua Gram Panchayat to act in accordance with the direction passed by this court in WPS such and such at the earliest but positively within a period of 8 weeks from the date of communication of this order. The respondent shall pass a reasoned order and communicate the same to the parties immediately thereafter. In the event the aforesaid respondent is of the considered opinion that the construction has been made either in violation of the sanction plan or devoid of the necessary steps shall be taken to deal with such unauthorized construction in accordance with law. Millard, this was the correction. Therefore, Millard, the primary duty was upon the Millard Nalua Gram Panchayat to consider the representation. If they found unauthorized construction, then Millard it will be sent to the subdivisional officer. Here, Millard Nalua Gram Panchayat did not take any steps, Millard, in terms of this order.
That's why the Chalamat Laskar. That's why the Chalamat Laskar
here, Millard, directly, Millard, the SDO has initiated that.
No. Thereafter, that was not also the second order. The second order of litigation was not complied by the concerned Pradhan, Gram Panchayat. Chalamat filed contempt proceedings. Rules was issued. WPCRC 60 of 2024.
Kindly comes to page 56. Page 56. Contempt, we were not parties.
Dismissed for default.
Yes.
Again, it
No,
was restored.
No.
We are not aware, Millard. We are not in contempt. It was only against Manna Mistri, who is the Pradhan.
And we came
In the
came to know from this letter.
pursuant to the direction
Came to
passed
know
in the
from this.
contempt proceeding, the SDO initiated the proceedings. It is the abandonment.
The order,
It is the
order at page 66 says that it is dismissed for default. What was the order passed in the contempt? You say rule has been issued. It is dismissed for default.
Kindly comes to page 57, Millard.
57 says notice of hearing in connection with
From
this.
there, we came to know there is a
Heard the
yes, pending.
No. From there, Milord, we came to know that in High Court, Milord, WPCRC 60 of 2024 is pending. From there, Milord, private respondent, Milord, will not be a made party in the contempt. That's why we were not made party. Milord, thereafter, I downloaded the order and Milord, this order I got.
এবার একটু আমি বলি।
হ্যাঁ, এবার বলুন।
Lordship, kindly come to page 6 of the petition, paragraph 11. Your petitioner state that 29th August 2024, that the said respondent number 2, that is the SDO, had initiated the proceedings in the light of the order passed by her Lordship, the Honorable Justice Amrita Sinha.
Page.
During page 6, it is his apartment. In the light of the proceedings, paragraph 11. And kindly come to my report also.
Not my
The
it is
report which I
from this
placed,
page.
the SDO, the page 2. Page 2, that in compliance with the order passed by the Honorable High Court in case number WPCRC 60 of 2004 in WPA 19827 of 2021 in the matter of Chalmat Laskar versus State of West Bengal, the SDO Diamond Harbour had passed the following orders. Heard the submissions of all the parties present at length, the
WPCRC 60 of 2024 dismissed for default হয়েছে
dismissed on subsequent date. But before dismissal, for us, this order has been passed to initiate proceedings.
Panchayat আছে তো, Milord, advocate for the Panchayat is present. He may say that.
I have not filed
Yes, dismissed for default. I have seen. That was dismissed for default.
someone can say.
আপনাদের রুল ইস্যু
এটার পরে কোনো অর্ডার কিছু হয়েছে আগে কোনো অর্ডার আছে দেখো payment of 10,000 in Treasury High Court Calcutta. Total? Reports and notice served upon this. কার আগের অর্ডারটা
He was put to cost, perhaps.
Your orders has to be gone in. আগে একটু আগে তো দাও 2-3টে অর্ডার আগে দাও একটু স্কিপ করে যাও দুটো অর্ডার একটু আগে মার্চে দেখো মার্চে 14th মার্চ ঠিক আছে দেখি নাও it has been submitted. They submitted that she took charge of the Pradhan on all against the time for such contempt application made returnable 18. হ্যাঁ 18 তারিখে দাও 18th April. একটু পরের কথাটা cost present না করো Next order to the ঠিক আছে তুলুন mentioned 13 June.
This is what we want to.
রুল তো কিছু ইস্যু
তোর সন্ধ্যা দাঁড়িয়েছিল।
নেক্সট তাই না ঠিকই তো বলছি when was this rule issued
That they are
when was the rule issued
At that time, I was not there. So I was not sure. I have taken steps. Sorry.
page
57.
page 57 is not very clear on that. It is their notice.
have you annexed the proceedings that was
Yes,
undertaken
yes.
by the Pradhan did not comply so as per you the rule was issued and SDO was directed to initiate the
Yes, yes, yes.
Cannot be Millard. Justice Sinha's order was Pradhan is to Millard consider the representation, and if unauthorized, he shall then Millard consequential. What are the consequential? Then according to 23(5), it has to be referred to SDO. Millard, we did not get as of today any notice from the Pradhan for to appear and to.
but if there is a order of the court passed in
Millard,
because
that is not apparent.
in no in contempt petition there is a cost upon the authority to deposit that and there is a non-compliance of the order
But there was
That's
no
paid.
modification of the original order.
no that is not modified if in the contempt petition if any
That is
direction is
punishment.
issued because a
That is
rule is issued
punishment.
then we have to see
That is punishment. But original order stands. Pradhan has to, and one there is no.
take instruction come back tomorrow at 2 o'clock
Tomorrow, Lordship, next week, Lordship.
My
tomorrow Okay,
time
hearing
has
will be
already elapsed, Millard, for demolition. They may come back on Monday, but Millard, kindly protection.
can you search it out and intimate this court regarding the orders passed in the proceedings
I
in the
can
second
take print out of all the orders, Millard, for your lordship. This much I can do, Millard.
I am,
Just take an
I am
instruction.
also,
in the second of so he has concluded his argument so that we can pass the order
I can, Millard, whatever orders were there, Millard, I can take it out for your lordship.
ঠিক আছে ফিরে আসি একটু you take instruction
We come back at 2 o'clock.
yes দুটোর সময় কিছু আছে কি আমার
তাহলে এই করা সবটা
Item number 14, well,
চলে যাচ্ছে
other side is I am paying for
কটা অর্ডার আছে
not a common court judge in this matter, my lord. I am paying for not today and tomorrow. He is in favor, my lord. He has not come. He is in favor, Mr. Kamal.
This item number 14, I am appealing for state, my lord.
I am for the Pradhan.
on the prayer of
Congress got taken.
appearance only on the prayer of the petitioner please this matter on 29th go next week again
Matter will appear
29th go
29th.
29th chalo on 29th
No, again,
29th
29th.
out of Milord, all the
On
pages.
16th
Milord,
May 2024,
I have a Milord. Order I have filed. This is the order of the SDO.
No.
Milord, 2 pages, Milord. I have Milord folded, Milord. Kindly see.
16th May 2024. The concerned Gram Panchayat referred the matter to the SDO, and this court directed the SDO to expedite the matter. Section 5. Yes. Lordship.
2 pages, Milord. I have folded, Milord. Kindly see, Milord.
This is contender number 2 is the Pradhan.
দুটো প্রধান ছিল একটা হাসপাতাল প্রধান স্যার
Who is contender number 2 in the proceedings? Pradhan. The document relating to proceeding a deal on this concern and following subdivision officer
Submitted by the
subdivision officer directed to expedite the matter and conclude the proceeding. Sixth May, you say
Yes, Milord. All the orders are there. I have folded those 2 pages. Kindly see, Milord.
16th May in WPCRC.
I have folded those 2 pages.
16th May 2024, WPCRC 60 of 2024. The second page, Lordship. From the affidavit in compliance affirmed by the Sitikana De. Sitikana. এখানে Sitikana তো লেখা।
relating to proceedings. So far as the proceedings is concerned, it has been referred to the subdivision law.
And section
No. Kindly see, Milord, what has been done. Kindly see, Milord, recollects the original order, Milord, of Justice Sinha. Justice Sinha said, Milord, representation is to be considered. Now, Milord, kindly see, Milord, here, Milord, in contempt, what is the recording? The Pradhan comes and says that it has to been referred.
This order cannot be interpreted in a separate proceedings. It says that subdivisional officer is directed to expedite the proceedings.
Expedite, then my
So-
previous order, kindly see.
So the proceedings has been gone to the subdivisional officer which
At
has
the
been
instance of the
considered
Pradhan.
and direction has been issued.
and in accordance with law.
Yes. Now we are with the order passed by the subdivisional officer.
Yes.
Because prior to that, I was in a confusion that whether there is a direction because previously the Pradhan was to consider. Now he cannot, subdivision officer cannot directly take up the proceedings.
Milord, may I place that, Milord? May I place that, Milord?
I was not made a party in the writ petition, but though the proceeding was initiated at my instance, the writ petition was filed by my client. But I also filed a writ petition challenging the order passed by the SDO.
Yes.
Milord, may I read out, Milord, subject to correction by your lordship, Milord? Kindly, may I place that, Milord? Kindly see, Milord, the 14th May.
16.
Yes. May I read 16th May order? Learned advocate representing the contemner number number 1 submits that that a sum has been directed to be paid to the divisional forest officer on section sub 24 Parganas has refused to accept, has to be accepted by the said officer. Of the photocopy of the account pay check has been produced by this court as the divisional forest officer sub 24 Parganas is alleged to have refused the said payment when the contemner number 1 is directed to issue the check in favor of the Registrar General High Court Calcutta received showing the deposit of the check in the office of the Registrar General be produced on the adjourned date. Then from the affidavit of compliance affirmed by Srimati Shriti De, the contemner number 2, it appears that document relating to the proceeding to deal with the unauthorized construction. Where is that document? Therefore, he must have dealt with without any inspection, without any hearing. What he is doing under the threat of contempt, he says, I'm following the law. 23(5), prima facie Pradhan has to come to a conclusion, then it will be referred to the SDO. No difficulty. Therefore, it is specific recording the document relating to the proceeding to deal with unauthorized. Where is that document? It must be in their affidavit of compliance. We were not present in the no notice of hearing, no inspection. What proceeding did Milord the Pradhan give? This is deviation, Milord, from the original order. Thereafter, Milord, her ladyship has been pleased to record, since the Milord, it has been referred to the subdivisional officer, or subdivision is requested to expedite. One. Now,
This has been, Mr.
very well, very well. Then, Milord, I have very well. Then, Milord, my other point is there on merits. Then, Milord, my other point is there on merits.
Since, see, the proceedings before the
Pradhan
SDO has reached from the Pradhan. You have not been notified in contempt, that has been, affidavit has been considered, and he has been directed to expedite. Had there been any legal infringement in the process of referring the matter, the court would have considered. Now the court has considered the affidavit, after being satisfied, directed the SDO.
Very well.
Now we are with the order of the
Very well.
SDO.
Then, Milord, I have
how far
already,
it is legally tenable or not?
already, Milord, satisfied your
You have
lordship.
made your submissions. Which is your writ petition?
My register 19420 of 2025. I was also filed within the same order. I am challenging this order.
This is appearing today.
I will deliver yesterday. Because I have served a copy of the order passed by the SDO. I have only ordered the on Monday. And immediately I will draft the petition and file it.
Because why they have challenged 1, 2, and 3 are their portion. Chalamat, I must say, he must be appearing for Chalamat.
I was not made party in this.
Not required. I'm challenging. Yes, yes.
At my instance. I was not party in the
I am agreed by the order of the SDO.
Okay. So stay the order of the SDO right now. Let both the parties file your affidavits and all.
Lordship, subject to correction.
With regard to us,
There is no apparent wrong in the order.
We'll examine that.
He was given ample opportunity.
It is not a question of ample opportunity, it's a question of 23 proviso. 23(2) proviso.
And 23(5), interpretation of 23(5).
Whether at all the permission is required for demolition of that, not that has to be examined. Asun. Affidavit of service filed on behalf of. In your writ petition, they are party.
no.
In your earlier writ petition, they were party.
I am challenging the order.
He has also done the right thing. Affidavit of service filed on behalf of the petitioner is taken on record.
Now, Milord, one. In municipal matters, Lordship knows, Milord, there is a after, Milord, the Special Officer Kolkata Municipal Corporation passes an order in 400 subsection 3, there is a provision for preferring appeal before the Municipal Building Tribunal. Milord, when Milord Municipal Building Tribunal, Milord, the person responsible or anyone, Milord, who is preferring appeal, the complainant is never made party. Only corporation versus.
This is against the orders passed. Okay. By the present writ petition, paragraph 1, 2, by the present writ petition, the petitioner seeks direction upon the respondent authorities, seeks direction for setting aside, cancelling, and or quashing of the order of demolition dated 30th July 2025, passed by respondent number 2, subdivisional officer, Diamond Harbour, South Chobbish Pargana. The petitioner contains that the প্যারাগ্রাফ ছোট্ট করে একটু একটা বলে দাও
ইউটিউবে চন্দ্রনাথ সরকার।
That petition number 1
Liberalization, যে notificationটা তো এখানে দেখা
There are three petitioners.
Yes, Milord. Abad, Milord. Yes, order has been passed
Petitioner.
against Milord 3.
আবুদ্দিন আর
Petitioners করে দিন। Contains that
Abad Ali Piada, Shahabuddin Piada, and
they are
Sabit Dorji.
residing within Kacha structure made of mud wall and asbestos shed.
One is a Goalghar.
Stop. There are no new construction made by the petitioners. The impugned order under challenge also does not records as to whether the constructions are new or old one. As such, the rigors of section 23(5) of the Panchayat Act 19 West Bengal Panchayat Act 1973 is not attractive to the facts and circumstances of the case. Attract. Being aggrieved and dissatisfied with the order of demolition passed by respondent number respondent subdivisional officer
Respondent number
2 subdivisional officer Diamond Harbour South 24 Parganas. The petitioner has preferred the present writ petition. Mr. Sounak Bhattacharya, learned advocate for the petitioner, referring to section 20 proviso to section 23(2) submits that না ওটা কেটে দিন referring to কাটুন indicates at the outset that the order has been passed on the basis of report submitted by the concerned Gram Panchayat. The report of the concerned Gram Panchayat clearly records that the houses are mud wall and bamboo fenced with asbestos shed. Therefore, those are kacha structures. Stop. Referring to section 23(2) proviso, he submits that no permission is required for making such construction. Further, there are also no restriction as to the extent of the covered area to be constructed of kacha and semi-pakka residential building. Therefore, the order of demolition passed by the subdivisional officer under section 23 is illegal and not sustainable in the eye of law. To be precise, there are no new constructions undertaken by the petitioners. He seeks for setting aside of the impugned order. Learned advocate, on the contrary, Mr. So-and-so, learned advocate for the state, submits that there is no illegality in the order passed by the subdivisional officer. The petitioner, such order has been passed in compliance to the direction issued earlier in WPA 19827 of 2021 and in WPCRC 60 of 2024. He seeks for dismissal of the writ petition. Upon perusal of the impugned order, it is found that the report of the Pradhan has been reproduced in the said order. The structures indicated under serial number 5, 9, 11 and 12, which is the subject matter of the present writ petition, are all Kacha structures. Reproduce. কি বলুন? Reproduced in the impugned order. Are all Kacha structures. Thus, it is found that an arguable case has been made out on behalf of the petitioner. Accordingly, the order dated, impugned order dated 2nd July 20, no? It's 2nd July? 30th July 2025 is passed by respond number such and such, subdivision of Diamond Harbour, is stayed for a period of. When can you file the report?
4 weeks.
Then need to go that side, you know. After vacation, then this will appear.
Okay.
If you can make it 2 weeks, then we can dispose it of prior to that. You will be filing. Where is the? You will be filing any affidavit?
3 weeks.
তাহলে এটা কি কাজ করবে? 3 weeks হলে কবে হচ্ছে? When can you file the reply? If it is 2 weeks, 1 week.
No, if it is opposition, then I have to file reply, and if they file report, then I have to exception 1 week.
2 weeks আর 1 week করো, 3 weeks পরে পুজোর আগে একটা ডেট দাও।
Opposition lordship or report?
আমাদের কবে ক্লোজ হচ্ছে ভ্যাকেশনে?
26 perhaps.
26 4 weeks যদি এটা থাকে কবে হচ্ছে?
21st September.
21st September. So 4 weeks or until further orders.
4 weeks
State is directed to file report in the form of affidavit within a period of 2 weeks from date. Advance copy be served upon the learned advocate for the petitioner. Exception, if any, be filed within a week. Same for you, affidavit in opposition. Release this matter after 3 weeks. 3 weeks for a date given. Returnable motion. 17th this will come up.
17th September.
Report দিয়েছে।
That's 1 week. 2 weeks, 1 week, 17th September.
2 weeks, 1 week.
Report in the form of affidavit.
He will file affidavit in opposition with direction.
Or I think further order, whichever is.
Panchayat will also file.
File his affidavit in opposition. He will file. What is your number? ওই নাম্বারটা নিয়ে এরপরে who is for the state in that matter? Mr. Mahato? আচ্ছা কি লিস্টে কি রান করছে এটা? In the list? আচ্ছা prior to 17th September, when the matter is listed, you mention before this court so that both the matters can be taken up. Huh?
কিন্তু হচ্ছে 50 টাকা নয়।
Item 14.
Great.
Item 1.
This is for non-prosecution, my lord.
Written instruction.
Yes,
This matter
ma'am.
is appearing under the heading to be mentioned. Learned advocate for the petitioner submits that the petitioner does not intend to proceed further with the writ petition. He files written instruction of the petitioner dated
17th August.
17th August 2025, which is taken on record. Here for the state, in view of the above, the writ petition being numbered 24948 of 2024 stands dismissed as withdrawn. On connected applications, interim order if is vacated.
Date.
Urgent. এই 14টা ডেট হয়ে গেছে 14টা ডাকবে না
Item 15.
Lord, in item 15, Lord, I appear virtually for the writ petitioners. My junior is present before your lordship physically. Lord, in this matter, Lord, there is a very innocuous prayer by the writ petitioners. Lord, some notifications have been issued by the state of West Bengal in respect of financial package for the Lord, casual and contractual employees. Now, the petitioners before your lordship, Lord, are working in Bankura district for about 2 decades. Lord, they are seeking the extension of the financial benefit in terms of the notifications issued by the state government from time to time, Lord, so that they can, Lord, get some relief. Now, Lord, things on earlier occasion, one writ petition was moved. Lord, division bench was also moved. Thereafter, Supreme Court was approached by the state. Lord, the extension of benefit of the notifications were provided to the panchayat employees also. Now, Lord, therefore, Lord, we are seeking, Lord, only relief. The matter can be disposed of by your lordship. Lord, if prayer 1 is considered by the appropriate authority, first prayer is considered by the appropriate authority, that would give certain relief to the writ petitioners. Lord. About 4 notifications have been issued, Lord, extending the financial package.
who is for
Lord,
Uh, Mr. Shivashish Banerjee, last time I notified him, and this is the affidavit of service. This is served. That's all. Before mentioning, I also notified. This is the
how
affidavit
many
of service.
petitioners are there
Total number
Lord,
of
they're all working as dual operators in different panchayat areas in Bankura district.
court fees have been filed
court fees, my lord. We have made a specific statement that if my lord so orders, we will pay the
to do that
required court.
But that can be filed, Lord, subject to your lordship's kind consideration within a week.
appearing on Mr. Roy Nani is appearing on behalf of the state. Now the state has to, since there are several petitioners, whether
Yes,
all
Lord.
the petitioners will be entitled to that has to be examined and assessed. Now the
No,
state
Lord, this is your lordship, Lord. I am seeking for not any mandatory direction. The appropriate authority would take into consideration and decide the issue, because
No,
they are seeking financial benefit. Lord.
prayer A is something else. Prayer A is of extending the financial benefits. If
Yes,
it had
that
been
is the only issue. But if the appropriate authority considers, Lord, that they are entitled in view of the division bench judgment of this honorable court, which is, Lord, affirmed by the honorable Supreme Court.
that is your,
Lord,
then you intend to have your representation considered by the authority.
yes, yes. Well, that would suffice. That would suffice, subject to your lordship. Because keeping the matter pending for further adjudication, I don't think, Lord, would serve any purpose.
Okay. স্টেট কে তো লাগবে না স্টেটের কি বাড়াবে কালকে এটা নিয়ে নিলে হবে yes you will appear who was appearing Shivashish Banerjee
Shivashish Banerjee was the at the time of mentioning, my lord, I also notified that
ये কালকে হতে পারে can you give a press notice
Yes, yes, I can.
Can we take it up tomorrow?
Yes.
কালকে এটা উপরের দিকে রাখুন। Affidavit of service filed on behalf of the petitioner is taken on record. None appears on behalf of the state. Learned advocate for the petitioner is directed to intimate the learned advocate for the state of the next date. এটা আগে দিয়ে দিন। List this matter on tomorrow. Tomorrow, sir.
All right. I am extremely grateful to my lord. Extremely grateful.
কালকে এটা লিস্ট রাখুন।
Item 16.
16. But I am applying for the petitioner. It's the affidavit service.
Private.
But I have filed this petition praying for unauthorized construction made by the private respondent. I made an application before the authority concerned. They did not turn up. That is why I am filed a writ petition, my lord. And in the year 2015, my lord, I made an application before the Pradhan Gram Panchayat for illegal construction. Therefore, they did not turn up or taking no step against the private respondent. I move a writ petition before this honorable court. This honorable court pass an order. Lordship, kindly see the order first. Page 28. 31 the operating department.
Pradhan. So you are appearing for state. You are for
Both.
I am for the private respondent 14 and 15.
service upon Pradhan. Pradhan has been served.
Then has been served.
Which is the track consignment report?
My lord. Page 9 perhaps.
Not served. It has not been served.
Item received.
Serve. Affidavit of service filed on behalf of the petition is taken on record. It is found that service upon respond number 6 is not complete. Petitioner is directed to learn, and advocate for the petition is directed to serve appraise upon respond number 6. Registered speed post with acknowledgement given by affidavit of service on the returnable date. Please this matter on next. When can this be completed?
1 week, within 1 week.
On Thursday. '28.
My lord, in this matter, I am appealing for state. In item 70.
My lord, Tanmay Mukherjee is appearing on behalf of the private respondent.
My lord, I beg to
Mr.
appeal for the, my lord,
Mukherjee has not
Panchayat
come
Pradhan.
to court today, my lord. And I'm praying for not.
I
Please, my lord.
I beg to appeal for the Panchayat Pradhan.
Panchayat Pradhan.
Yes, I've served all.
Sir, Pirulia Gram Panchayat.
What is the case?
So, my lord, this is an unauthorized construction made by the private respondent who have served. My lord, kindly see the page 38 first.
38.
I have made an application before the BLRO whether the land was converted by the private respondent or not. The reply of the land block development report officer that the opposite parties have not got any permission in conversion case. The first point. Next is page number 39. Reply of the concerned Gram Panchayat, Gram Pradhan.
Yes.
The reply. অত্র গ্রাম পঞ্চায়েতের গৃহ নির্মাণের অনুমোদনের নথি পর্যবেক্ষণ করিয়া এই সিদ্ধান্ত উপনীত হওয়া যায় যে অনুভূঁইয়া মৌজায় যে জেল নাম্বার 133-এর সাবেক দাগ 806 ও হাল দাগ 895-এর উপর 2010 সাল থেকে আজ পর্যন্ত গ্রাম পঞ্চায়েত থেকে কোনো গৃহ নির্মাণের অনুমোদন দেওয়া হয়নি। Thereafter, my lord, I have made an representation before the authority concerned, Pradhan, particularly for removal of the illegal construction. They did not take any action till date, my lord. Page 40, my lord, the representation.
Yes.
My lord, may I'm appearing for the my lord Panchayat. My lord, it transfers from the my lord page 39 that my lord already we have my lord this my lord notified that there is no sanction plan at all. And my lord, we shall decide on the basis of this representation, my lord, let it be sent to the my lord Pradhan and we'll decide, my lord, later. My lord.
In which matter, lordships?
Well, they let the representation go before the Pradhan.
Lordships, I have obtained, lordships, kindly look into this. Already the private respondents had got the permission, lordship, from the government to construct the, already the grant has been, lordship, the Indira Vikas, Prokolpo, lordships. That grant has been permitted in favor of my 3%.
So show it to the Gram Panchayat where it is.
The lordships, that permission has been granted by the Pradhan. They already, on that ground, the construction has been done. The money has been already released in favor of the grant, the already grant released by the government. The Indira Vikas Prakolpo, lordship, on that scheme, he has constructed the building. The government had introduced the new scheme that permission should not be required. When the scheme has been introduced, the grant has been permitted by the government. And in the meantime, the lordships, the suit has been filed. The already partition suit is pending before the trial court, lordships, the whole year. In the meantime, on the self-said plot, the suit is pending.
Yes, suit pending regarding the partition suit. I am concerned. I am concerned about the illegal construction, my lord.
In the meantime, lordship, he has obtained the grant from the government, the Indira Vikas Prakolpo.
Show me the papers.
Lordship, that is why, Lordship, let it be adjourned on Monday, let it be taken up. Okay, I will show the entire document, the suit is pending. And on the same plot, the petition suit is pending. I will bring it and I will show it the plaint and the entire order.
My lord, may I,
Lordship, kindly visualize the situation, let it be adjourned on
Lord,
Monday, let it be
my lord,
taken
may I
up.
suggest, my lord, your lordships, my lord, kindly, my lord, send it to the my lord Pradhan, and Pradhan will consider after hearing.
Will not be
My lord,
decided at
all those my lord records are not,
Lordship, I will show the plaint.
those records are not available to the Pradhan, my lord. That's why, my lord, it is my instruction.
Affidavit
My
of
lord.
service filed on behalf of the petitioner is taken on record. You are for private response numbers?
Lordship. Respondents. Lordship, 10, 11, 12.
10, 11, and 12. Learned advocate for private response 10, 11, 12 seeks accommodation to produce relevant documents. Oh, sorry. Submits that the construction has been undertaken by the private respondents under the scheme Indra Vikas
Prokolpo, Lordship.
Indra Vikas Prokolpo, and fund has already been sanctioned in their favor. He further submits that partition suit is pending by and between the parties. He seeks
Lordships, the
accommodation to
Pradhanmantri Jojana. Lordship, instead of Indra, because Pradhanmantri Awas Jojana.
Pradhanmantri Awas.
Lordship.
Seeks accommodation to produce relevant documents.
Bangla was Jojana.
The Bangla Awas Jojana.
Under which Awas Jojana you are making construction?
Bangla Awas Jojana.
Now Pradham Indira. তারপরে এলো
Lordship, radically
Which one?
changed, Lordship. That is-
radically changed. These are different schemes.
Lordship, in the meantime,
Which scheme you are?
initially, Lordship, the Pradhanmantri.
Sir, I am recording order. You tell me what is Bangla
Bangla Awas Jojana.
under Bangla Awas Yojana. থাকবে next week. Thursday, Friday, Thursday করে দিন 28. 28. 28.
In the meantime, my lord,
Virtually appear করেছে.
my lord, in the meantime, may I file any
ঝুমা
report?
চক্রবর্তী।
In the meantime, may I file any report?
এটা নিন্দো your response number?
I'm for the my lord, Panchayat Pradhan, my lord. This response numbers 5 and 6. 5 with the Panchayat and
No, 5 and 6 is directed to file report in the form of a report on the returnable date.
Yes, I'm great.
Well, in this matter, I am for the petitioner, my lord. I have served, I have sent, my lord, all the respondents, but my lord, tracking is not available in respect of Pradhan, my lord. Because, my lord, due to some problem was going on in the postal department, due to software developing, my lord. So, my lord, in
Is a
respect of,
document from the postal authority regarding service upon response number?
well, I serve, it is, I serve again, my lord, upon the Pradhan, my lord.
Advocate for the petitioner submits
Response number 3.
affidavit of service.
This is the immediate service.
Affidavit of service filed on behalf of the petitioner is taken on record, and an advocate for the petitioner submits that due to technical glitch in the server of the postal authority, the track consignment report could not be obtained. The others have been served
The other servant have served.
in respect of response number 3, Pradhan Anara Gram Panchayat. দেখে নিতে হবে। এটা দিয়ে যাও। কি হলো? এটা দেখুন। ঠিক আছে। Wait. No. 3. The above petitioner is article to appraise upon respond number 3, register speed post with acknowledgement due and file affidavit of service on the returnable date.
Kindly adjourn for,
Is state is there?
well, state is not here, but
It is unrepresented.
this is another notice I have given the state. Well, date fixed for my lord.
On the 4th September.
Well, on top, well, as reminate position, my lord.
Next.
Item 19.
Nothing.
So the petitioner was appointed for the post of Sahayak. Now, Lordship, petitioner was recommended in the 23rd February 2006 by the concerned Commissioner of Panchayat and Rural Development Officer in petitioner in the post of Sahayak. Now, petitioner, Lordship, the joint petitioner appointment letter was issued in favor of the petitioner for the post of Gram Panchayat. Petitioner was subsequently, Lordship, the joined in Ghoramara Gram Panchayat.
Ghoramara.
Yes. Ghoramara Gram Panchayat. Subsequently, in 2017, the petitioner was transferred from Ghoramara Gram. Sorry, initially Chandpur. I'm stand corrected. Initially Chandpur Gram Panchayat. Then petition was transferred from Chandpur to Ghoramara Gram Panchayat, which is under Domkol block in the district of Murshidabad. Now, since 2017, petitioner has been discharging his duties. Now, all on a sudden, what happened?
The Murshidabad Jila Parishad, you have served?
Lordship, everybody is track report available? Yes, Lordship, kindly consider the every service I have served.
District Panchayat, District Block Development Pradhan. It is not there. Respond number 9. Kindly find it out. এটা দিন তো
এই জেলা পরিষদকে সার্ভ করেছিলে সভাধিপতি জেলা পরিষদ সার্ভিসই করিস
not sir.
Lordship, the authority is the district magistrate.
You have made party. I am asking you whether 9 has been served or not. Check.
Sorry, Lordship, this is my instruction, not this, sir.
Affidavit of service filed on behalf of the. When can this be completed?
So within a week.
You are for Mr. Mithro?
State respondents.
So you are for 1, 2, district magistrate, district panchayat, block development, 8 and 9. Affidavit of service filed on behalf of the petitioner is taken on record. It is found that service upon respond number executive officer has been served. 8 and 9. 8 and 9 has been
Executive of the জেলা পরিষদ সার্ভ হয়েছে হয়েছে Lordship, the executive officer জেলা পরিষদ has been served.
then on serve upon the Murshidabad 9 case শুধু সার্ভিস করে আসবে হ্যাঁ
Lordship, this is an application for transfer. The executive officer is the authority, Lordship.
serve upon respond number 9 and file affidavit of service on the return. Yeah.
আমার বেশি একটা চান্স পাওয়া যায়
When can this be completed?
So within 1 week, lordship,
Next week তো ছেড়ে fourth, third বা fourth দিয়ে দাও। 4th September.
4th September. So only I serve the Jela Porichad.
Only 9.
Great.
And may I file my affidavit of service, my lord? I've complained of an unauthorized construction before the local Gram Panchayat. My representation is at page 12, my lord. I've given the pictures at page 13, my lord. I have specifically stated that this is an unauthorized and unapproved structure. This was issued on 2nd
Which
June.
plot this is? This has been undertaken on which plot?
We'll kindly come to the first paragraph, my lord. Page 12.
It says grandmother was the lawful owner.
This is written plot number 1593, Khotian number 119, district Malda,
The petition and others.
Balupur Mauja.
11119.
Khotian number 1119 and the plot number 1593.
Okay. And the private respondents, who are these persons? They are other legal heirs of your grandmother.
The private respondents are
Brothers.
very likely, yes, they are brothers, my lord, and they are the people who are raising this unauthorized construction. Served all my
Private respondents, sir.
served all my served all. We have given a mentioning notice as well.
Only I have.
Whether served or not. 369. ಇಲ್ಲ. Asking 369.
Represent.
This is incomplete affidavit of service.
What is that?
It is Nasim is respond number 7. His track consignment report has not been annexed. Now this Samuel is 386. 386.
Samuel কত? 86.
It is also not.
386.
Siboti Pradhan 390. Nothing. It is not. Return.
এই জিনিসটাই এক রিপোর্টটা
None of them are. The Pradhan is not there. The private respondents are also not there. Check.
I'm extremely sorry. দুই তিন চার পাঁচ ছয় কটাই তো আছে
পরপর দেখবেন এটা কি ওটা নেই
একটা কি দুবার করে দিয়ে দেওয়া যাচ্ছে নাকি
আপনার আছে দেখি স্টোরে
69
Affidavit of service filed on behalf of the petitioner is taken on record. It is found that service upon Pradhan, you have got it? No, it is not there. Service upon respondent numbers 4, 5, 6 and 7 is not complete. Learned advocate for the petitioner is that will serve upon respondent numbers 4, 5, 6 and 7 and file affidavit of service on the returnable date. এই আরো পরে চলে যাবে
রিপোর্ট লাগানো সবসময়
তাড়াতাড়ি 4th September, this can be completed.
My will kindly gives me a short date. I'll complete it as soon as possible, and if it can retain its position, madam.
On 4th September then. On 4th.
Let it retain its position, madam. That is my humble prayer, madam. I am extremely
Prior
sorry.
to mentioning the matter, you could have checked the records.
I should have checked the affidavit of service. I relied on.
Okay, let it come up on 4th. Let's see. Huh? বলে
But
সার্ভিসটা নিয়ে রাখো ওটা ইনকমপ্লিট আছে স্টেট তো অ্যাপিয়ার করছে registered speed post with acknowledgement file yes 4th September next
Item 21.
For the state laid by Ms. Jhuma Chakraborty.
Please, ma'am. This is my writ petition.
My lord.
Prior to entering into the merits, that I must say, this is my affidavit of service with respect to the private respondents. It has come back as returned, but possibly, my lord, their locus here is not a question because I have challenged an order of demolition passed by the respondent authorities. So, if it is my lord's opinion that in their absence I can proceed, I shall proceed.
No.
May I, my lord?
Serve on the private response. If it's incomplete, private.
It is incomplete, my lord. It is incomplete.
The affidavit of service filed on behalf of the petitioner is taken on record.
No, my lord.
On the service has not been effected upon respond number.
Respondent number 4. I should just check.
10. Private.
10. Yes,
10.
private respondent. Lord, may I just say this, Lord? This proceeding.
Others have the Sabhapati Bali Jagacha Panchayat Samiti. This has been served.
Yes, everyone else has been served.
Okay. Give.
Yes, ma'am.
Date will be for 1. Executive 6, 7, 8, 9. Act 2. Bali Sabhapati Bali Jagacha Panchayat 116.
Page 25 is the only tracking report in respect of
Not sure.
the private respondent, which says the returns are confirmed.
Right.
36.
Bali Jagacha.
Right. Advocate report serve করে দেবো যে ফাইল করেছিল?
Do not serve.
I'm sorry, Mila.
Bali Jagacha Panchayat Samiti not served. No. Sabhapati.
Kindly give me a moment. Shabhapati, serial number 3, 6120.
Not served. Unserved. Executive officer 133.
120.
Not served.
Consignment.
Soho Shabhadi. Shabhadi 41 code 7. Answer. Executive engineer. Executive engineer 155. Answer. Serve afresh. Affidavit of service filed on behalf of the petitioner is taken on record. It is found that service has not been effected upon the respondents. State is represented. So 1. State would be for 1/6. How would a PWD work for state? 1, 6, 7, 8.
May I just make one submission?
1, 6, 7, 8, 9. So, utake baad diye, London advocate for the petition is ready to serve afresh upon 2, respond number 2, No, 225 and 10.
Delivered.
225 and 10.
May I just make one submission with respect to the respondent number 10 only. With 2 to 5, my lord, I am bowing down. I apologize for an incorrect submission being made. Lord, I was under the impression they were served. With respect to respondent number 10, Lord, this demolition order is pursuant to writ petition filed by the respondent number 10. I have served in the address given in the cost title. However, each time it comes back as returned. May I seek the liberty to see the file, serve the advocate on record in the erstwhile writ petition of the writ petition?
No, you serve a phrase upon him.
It comes back as returned.
We'll see. এটা fourth এর পরে দাও, fourth এর আনবে না, অনেকগুলো আছে সার্ভিসটা আমরা 10th এ দাও, 10 September 10th.
Lord, could it be prior, Lord? May I?
Prior 4th September is the date. Thereafter 25 it starts on next week, that is on 10th. If it is 4th, can you
Only
complete?
issue is, my lord, the order is of demolition.
Then on 4th September.
That is my only.
It has to be completed.
I will.
On your
yes.
mentioning this has been listed.
Yes.
Now it is not. Service is incomplete. ঠিক আছে, 4th এ রেখে দিন, 4th.
Extremely obliged.
Yes.
I can go into
The 22, my lord.
22 I am having.
Petitioner. Lord, kindly, my lord. Generally, I do not seek any time, my lord, but in this case, my lord, my landed junior could not get the proper instruction.
Tomorrow.
To file, my lord, your lordship pleasure was that I should file a report that is not ready, my lord. He could not get.
There's a previous.
Well, we would file a report, my lord.
Earlier direction was there.
Earlier, there was
17 January 2024.
Kumar Mitro, learned advocate for the state, seeks accommodation to file a report in terms of order dated 17 January 2024. Earlier order, dated Batit. Earlier order. In terms of the earlier order.
Lord, 10, Lord, within.
Lord, may I submit one thing, Lord?
Lord, 10 this time, Lord. Oh, 10th September, Lord. Lord, 4th, then 4th. 4th September, then, Lord. I'm grateful, Lord. Now, immediate.
Lordship, I am for the state.
It matter to say does not relate to lordship the Panchayat. It relates to land.
Lordship.
Lordship, get to it.
My lord, I am for the petition led by Mr. Ornava Banerjee. My lord, in this matter, my lord, on the last order passed on 8th of April, and on this date, the London State Advocate was not appeared, my lord, and in this thereafter, my lord, we have served the respondent authorities, but somehow we have misplaced the receipt, postal receipt. So, my lord, that's why, my lord, we have served yesterday itself. Service is not so prepared. My lord, kindly take it up 1 week or 2 week later. Kindly take it up before.
I'm appearing for the state.
My lord, on the last order, there was an order to file and report. My lord, kindly if they
Your lordship. Lordship.
kindly pass over it, then my lord, we will reply back to the report date.
Your lordship, this is in respect of taking away land and demolition of boundary wall in a panchayat area by some unidentified persons. Now they have made some representation to the panchayat authorities and to the police authorities. The police has registered a case and FRT has been made. The matter has already, because it was against unidentified persons. So I believe there's nothing.
My lord, no private response.
No private response.
My lord, the allegation was against the panchayat authority because my lord, the persons who came to demolish that they are declaring themselves they came from the authority of panchayat, and they have threatened also. My lord, kindly see the complaint, my lord. I was
When I fail to
my boundary wall on my land was, my lord.
Because to my understanding, this relates to a police in action matter, if at all.
Sorry, my lord. My lord, actually led by Mr. Arnav Banerjee, he is absent today due to his. Kindly take it up tomorrow itself. May a copy of report be supplied to us? Yes, my lord. That was the direction on the last.
And it would require some more time, your lordship, since it has come from the police authorities directly.
Then, my lord, kindly keep it after 2 weeks.
And if your lordship intends that we would file a report in form of affidavit, we may do the same.
Yes, my lord. My lord, we are going to PPR, but my lord, somehow we have misplaced, my lord. When, my lord, we have discovered that postal receipt is missing, we were immediately yesterday we have served, my lord.
Yes, sir.
Apologize.
Your lordship, this signed report will be
posting on
kept
when?
record, or will I file a report in form of
Lordship is posting on when? Grateful, my lord. The Great.
25, my lord, I am appearing for the petitioner.
My lord, I am appearing on behalf of the Bardhaman Development Authority.
My lord, the allegation is, my lord, unauthorized construction made. My lord, may I file the affidavit also? My lord, allegation is, my lord, unauthorized construction made by the private respondents. My lord, I am the, my lord, petitioners are the owner of LR plot number 263. And my lord, the private respondents, they are the owners of LR plot number 254. My lord, a strip of land of 254 was purchased by the petitioners, about 6 feet wide, my lord, and 67 feet long, for the ingress and egress to the petitioner's plot of land. My lord, on that portion, my lord, the private respondents have made unauthorized constructions, my lord, constricting my passage. That is my grievance. I made representations. No, I have purchased, my lord, I am the owner of
Yes, for my ingress and egress, I have a relevant deed to that extent, which is plot number 254. On that strip of land, my lord, which is my ingress and egress, my lord, they have encroached upon, and my lord, they have made construction. Yes, I purchased that, my lord, under compulsion from them, and there, my lord, the illegal constructions, my lord, my passage is constricted. I made a representation.
Paragraph 4, my lord. Your lordship. Question of encroachment arises, my lord.
No, unauthorized construction, I have stated.
Yes, my lord, they applied the 6 feet wide lane, my lord, recently, but the building of the said premises is very long, my lord.
This is a wrong submission, my lord.
No, my lord. No new construction made.
Let the authorities inquire, my lord, into it, my lord. My lord, the panchayat authorities, my lord. Ran one panchayat. BD also. My lord, it is within the development authorities, Bad one development authority.
Construction has been done, my lord, deviation of the and some deviation is there, and ingress and egress has been obstructed of the petitioner. But allegation of encroachment is also there, my lords. Regarding the allegation of encroachment,
My lord, my grievance in this writ petition is with
no right to.
My lord, the Gram Panchayat ran one, respondent number 2.
Seeks direction upon the respondent authorities, particularly respondent number 2, to consider and dispose of the representation of the petitioner dated 9th. Which one you require? 9th August or 9th?
My lord, the subsequent is the reminder. I have annexed, my lord, both the 9/9 and 9/8. This is the first representation, 9/8.
9th September 2024. The petitioner contains that he is the owner of plot number, owner and possessor of plot number 263, Taylor Khatian number 4821, 4822, 4869, and 12351 under jail number 66, Mauja Ryan. He is Bardwan district, Purbo Bardhaman. The private respondents are the owner and occupier of LR plot number 254, which is adjacent to the petitioner's land. The predecessor in interest of the petitioner purchased an area of 6 feet wide and 67 feet long of a portion in LR plot number 254 from the predecessor in interest of the private respondents for making a pathway for ingress and egress from their landed property at LR plot number 263. The private respondents number 5 to 7 have undertaken unauthorized construction, which has obstructed, without any valid sanction plan, which has obstructed the ingress and egress of the petitioners. Petitioners. A representation was made. The petitioners made representation before the local Gram Panchayat, respond number 2, for redressal of their grievance on 9th August 2024 and 9th September 2024. However, no steps have been taken, hence this writ petition. Mr. Uttio Roy, learned advocate for the petitioner, submits that the representation of the petitioner may be relegated to the local Gram Panchayat, that is respond number 2, for consideration disposal. Learned advocate appearing for private respondents, on the contrary, submits that no new construction has been undertaken by the private respondents. Both learned advocates for the state as well as Bardhaman Development Authority submit that matter may be relegated to the local Gram Panchayat, to consider the representation petition. Upon hearing the learned advocates, যা থাকে প্রধান দেবেন না, respond number 2, রায়ন গ্রাম পঞ্চায়েত 3 months করে দেবেন। Disposed of.
Deeply obliged.
Original side আছে?
Next matter, my lord, I am for the petitioner, my lord. Original side. Oh.
Yes, sir.
আজকে হবে না, প্রত্যেকদিন কাছে এসে থেকে যাচ্ছে এবার।
আমরা বদমাইশ হয়ে এখন
May I be permitted to mention, my lord, this bunch of matters, my lord, which is due to appear on next Thursday, my lord. My lord, I too have some of the applications, my lord, just filed, my lord. The reason why, my lord, I pray, my lord, this let my applications be appear as under the heading new motions, my lord.
Why?
My lord, because
No news.
unless it be clubbed with,
My means whose application?
my lord, there are several applications, my lord, where affidavit have been exchanged, my lord. These are being taken up before.
What I am asking you is, you have indicated my application. My means who?
My lord,
What
on
is
behalf of
your
the respondent
handle
trust.
in the present proceedings?
Respondent trust, my lord.
Trust.
Respondent.
So they will appear serially with that matter.
Yes, my lord. Let it appear. Right. My lord, one further, my lord, leave I am praying for, my lord, to file the Vakalatama on behalf of the respondent trust, my lord. My lord,
My lord, may I mention the matter, my lord? I filed an application as a receiver, my lord. The matter was to appear today. My lord, same matter, but it's not appearing. So it appears under heading new motion. It's a new application.
Motion. All the applications will be appear along with the other motion.
My lord, but what is happening, my lord, the new motion?
লিস্ট করে হ্যাঁ
My lord,
যেগুলো আসছে সিরিয়ালি ওটাকে নেক্সট উইকে লিস্ট করে দেন।
but my lord, new motion is taken up first, my lord. It is without, my lord, it is a new motion.
চলো রাখো।
Lord, I appear for the petitioner. Lord, this is an application for review. Lord, there is an application for condonation of delay GA1. Lord, 79 days delay. Lord,
And my lord, I was praying
I
for
don't
leave to
think,
use
Lord,
an affidavit.
79 days delay, my Lord.
Lord, I have to use an affidavit because there are certain allegations which are
Right.
made on application which are perhaps not fully
Let
correct.
us see what are the allegations, my Lord. If required,
Come with
my Lord,
an
my Lord
affidavit,
will,
I
my
cannot
Lord allow,
deny the
my Lord,
use of an
my Lord
affidavit.
ignores those allegations. Let him file affidavit in the main review. There is
No,
no
I
point.
don't-
79
let
days
the-
delay only.
First, let the review
79
be
days
admitted.
delay.
First, let the section 5 get over, my lord. You cannot come and just make an application for condonation of delay and make incorrect
Between the
statements on
court
oath.
and me, my Lord, 79 days delay.
Yeah, one, my lord,
Lord,
I'll
kindly
give it
shorten
to
the
you.
shorten the period. Shorten the period.
Lord, the litigant
Lord,
who
may
comes
I,
to court late says shorten the period.
Lord, may I beseech your lordship, my Lord, may I beseech your lordship one. But since they are using an affidavit, let them use affidavit against the section 5 and the review application also. If my lord rejects the section 5, my lord, review would not be taken
Who
up.
will
If
pay
my lord
my
allows
fees
the
if
section 5,
section
then
5 is rejected?
my lord
That
will.
is not the process.
Section 5 there are
As well as
how can there be a direction in the review?
79 days delay only.
Not
Lord.
admitted.
Allow, kindly direct them to file it with the shortest possible time, Lord.
That your lordship will.
For the এক সপ্তাহে file করো।
This is an application for
No, not পুজোর ছুটি. Within a week you file it.
filing of a
No পুজোর ছুটি.
নিজে আসে।
What is the point?
আবার বলে অন্য লোককে তাড়াতাড়ি দিতে।
then an advocate for the risk.
তুমি 8 দিনে ফাইল করো, আমি 80 দিনে এসেছি।
They will
File
follow your cue.
affidavit in opposition to the application for condonation. Let's search within a period of এর আগে পুজোর আগে নিতে পারো।
Let us come back before vacation for section 5 only, Lord.
Look,
within a period of
today we are on
যদি আমি
21st.
6 year 1 week তাহলে কোথায় গিয়ে ল্যান্ড করবো?
কদিন নেবে? এক সপ্তাহ? 10 দিন?
2 সপ্তাহ
দু
স্ট্যান্ডার্ড
সপ্তাহ?
হবে
এটা 2 সপ্তাহ না কেটে
কোর্টের 2 সপ্তাহ কিন্তু।
থেকে within a period of 1 week.
Yes.
2 weeks, my lord, my client.
79 days.
2 weeks, my lord, kindly give us. My lord, they are out of time. They should not be dictating, my lord, how fast I can file my affidavit.
I can only pray. I have no capacity to dictate anything to anybody in the world, my lord. I can
Kindly
only
give us 2
pray with
weeks, my lord.
before your lordship, my lord. Let them file it within 10 days. 5 days for affidavit. Let us come back after 2 weeks.
হ্যাঁ ওরকম করে 10 days 10 days take
10 days. 10 days.
10
Lord, 10 days and 5 days.
হ্যাঁ after 15 days দিয়ে দাও
Lord, may we come back on 4th of
reply 5 days
4th of
advance
September,
copy, 5
Lord.
days thereof we file for
Yes.
reply 15 days for a date দিয়ে দিন
Lord, 4th of September will 15 days will be 4th of September. May we come back, Lord, on that day, Lord.
4th of September হবে কি
একটু দেখুন না। Thursday, 4th of September is a
তাহলে
Thursday.
11th এ চলে যাও
Release of
4th so ঠাক্কর 4th
Yes, please.
Lord, may it retain his position, Lord, in the list, Lord. দেখতে পেলাম। ঘাড়নাড়াটা দেখতে পেলাম না। I could not see your lordship, Lord, whether he was nodding the head or not nodding. I could not see him, Lord.
I can give you more what I have I can give you
Let it
on
retain his
5th
position.
September.
Let it retain his position, Lord.
That's why I'm asking Mr. Thakkar whether he has any problem or not on
No,
4th. On 4th September.
Grateful.
Watch out.
My lord, item number 2, my lord, Mr. Choyan Gupta, my lord, is just on his legs. I'm humbly praying for short passover.
Mr. Gupta indicated that he would argue. I believe he's on
Yes,
his
yes,
legs.
yes.
But
Short passover, if my lord kindly.
একটু রাখো passover.
Lordship, this is my application for the recalling of the order dated 13th of January 2025 passed in this matter, Lordship.
Yes.
Lordship, this matter is connected with item number 8 of your Lordship's list.
Okay.
They have also prayed, the joint receivers in this matter have also prayed for the recalling of the said order. Lordship would recall that on the last occasion, Lordship had directed me to serve a copy of this application on the state, which I have done, your Lordship. So my application, should I start if their application, they are ready to withdraw, I mean, recall that said order and
we are also praying for recalling of the order. There are certain mistakes in the order.
then I have no objection, your Lordship. Then my application also goes in the same manner.
Page 164.
My application, 164.
Yes.
Lordship, I'll tell you why. The reason that why I have sought for a recalling of this order. Lordship, my client is an intervener in this suit. There was an agreement for sale which was executed between the joint receivers and my client, your Lordship. Then after that, this was in respect of certain holding numbers 53, 54, 55, 56, and 57. Lordship, why am I specifying these numbers? Because that's the main reason that where the discrepancy has occurred. And why have I come before your Lordship for recalling of this order? So after
there are same mistakes also on our part also. So it should be recalled, but not if
I have no objection to that. So my main reason was that agreements for sale was executed in respect of the same holding numbers in respect of which this order has been taken out.
Yes, discrepancy in the description of the property.
Your application is 273.
Yeah, yes, your Lordship.
274. From our side,
you are for in 274 is your application.
Yes.
Both the applications being GA 273 of 2025 and GA 274 of 2025
Joseph Khutila recorded
has been filed for a recalling of order dated 13 January 2025. Learned advocate for the petitioner in GA 273 of 2025 submit that previously the properties where agreement for sale was entered or sale executed?
Agreement for sale was entered.
Agreement for sale was entered between the joint receivers and the applicants. It's applicant or applicant?
Applicant, Your Lordship.
Applicant. Comma. Which property has been included in the application seeking leave to sell the property, being GA 206 of 2020. On such grounds, he seeks for recall of the order. Learned advocate for the applicant in GA 274 of 2025, who is also an applicant in GA 206 of 2020, does not raise any objection, and they also seek for recalling of such order. In view of the aforesaid submission, the order dated 13 January 2025 passed in GA 206 of 2020 stands recalled. The GA aforesaid GA applications stands disposed of.
Lordship, one more indulgence, Lordship. If they are dealing with any of the properties in which is belonging to me, which in respect of which they have entered into agreements for sale with me, Lordship, a notification or a notice be given to me before they try to sell.
What we are praying, my lord?
Because there's an application already pending, Your Lordship, GA 225, taken out by the joint receivers for sale of the said properties to me, which is there. So that, Lordship, my humble request is that if they are selling any of the properties which is in connection with my property, a notice should be given to my client.
My lord, in our application, we are praying that this should not have observation that liberty may be given to file fresh application.
So there is nothing in the order to seek a liberty.
Yes, there is no such
There can be a application for.
Then this should not prevent the petitioners to.
No, I'm not preventing anybody.
Apprehending that if an application is placed before the court and similar order is passed, then again she has to come to the court for recalling. So she wants to have a notice from the joint receivers if any application is filed.
That is not a separate issue. They will take care. We shall take care.
Lordship, let them be that a direction be given in that respect.
The joint receivers are directed to notify the applicant of GA 273 of 2025 of any application subsequently to be filed concerning the properties in respect of which agreement for sale has been entered into between the applicant of 273 of 2025 and the joint receivers.
Yes.
But because, my lord, why the second round of litigation cropped up? Because they initially there was an agreement. They failed to give the value, price of the property. Naturally, we had to enter into with other person.
That was not indicated, but then that sale has to be cancelled.
That has not been cancelled. It's still in force.
They failed.
Anyway, if
have
any
not
subsequent application is filed, notify them that.
Grateful, Your Lordship.
This was. এটা না এই দেবাঞ্জন ওটা না আমাকে একটু রেকর্ডের সাথে পাঠাবে অর্ডারটা। হ্যাঁ, দুটো অ্যাপ্লিকেশনই পাঠাবে, মানে অর্ডারের সাথে দুটো অ্যাপ্লিকেশন পাঠাবে।
গ্রেট।
Now, this is my application, Lord. Lordship, remember.
Where is Mr. Bhattacharya?
Lord, he is engaged in a fixed matter before the division bench in courtroom number 16, my lord.
But see, this is pending since long.
Yes, my lord, yes.
Now the applicant, they have moved this application since long. This was released and again this came back upon assignment. And Mr. Bhattacharya started his argument in the meantime. Last 2 days, 2 dates, I suppose, he was not there.
Yes. But today is After that
You
matter,
tell
my
me
lord,
which
to be-
date this matter can be taken up. He will argue the matter, then they will reply on the prayer of learned advocate for the respondent. On the prayer, accommodation is sought for on behalf of Mr. Sonak Bhattacharya, learned advocate for the respondent. Next Thursday, পরের Thursday দেখো 4th এ যদি করতে
4th September. Yes, 4th September. Sir, হবে 4th September.
I am okay. My lord, peremptorily, kindly make it peremptorily, my lord. Otherwise, it will never end. It will continue, my lord, for eternity.
Mr. Bhattacharya will place his arguments, my lord.
That is, you were saying earlier also. But kindly make it.
Ask Mr. Bhattacharya to argue this matter.
Yes, my lord. Yes, my lord.
On 4th
He
September.
will place, my lord. He will place.
The third time they are making this.
4th September.
Yes, my lord.
কোনটা একটা পাসওভার কি হয়ে আছে? পাসওভার নেই? কত দূরে আছে? আসবে। দেখো নেক্সট দেখো।
But I appear for the receiver against whom an application has been filed by the petitioners, my lord, the respondents, my lord. The difficulty is, my lord, we have filed the petitioner's report as was directed by the court. My lord, only problem is, my lord, being unwell, my lord, I am not in person before your lordships, which I would like to appear in person before your lordships and argue the matter. So, my lord,
For your substance, I am fixing date.
No, ma'am, today, tomorrow, next Thursday, Thursday day after, up to your lordships.
I only say this, my lord, my application was filed in April 2022. The petitioners have concluded their submissions long back. The plaintiffs have concluded, my lord, this application is, my lord, principally, my lord, defendant numbers 2A to 2H has taken out this application.
Mr. Ratul Das appeared.
Mr. Ratul Das appeared on behalf of the plaintiff, my lord. Both of us had completed our submissions long time back, my lord. This application is principally for discharge of the receiver, my lord.
কুন্ডু
lordships.
4th এ রাখলে হবে না, সব 4th এ গেলে কি করে হবে?
May I humbly submit this, my lord, because this has been delayed for so long.
Your lordship will give me the 28th also.
And my lord will thereafter hear and finish.
Your lordship will bus you on 28th also.
No. I will give only one note. I will give only one note. Let us exchange notes. My lord, I mean, why next week? It can be fixed after 2 weeks also. But let it be concluded, my lord. We had more than 3 years have passed, my lord. I filed this application in April 2022.
তাহলে একটা কাজ করো না। 11th ই রেখে দাও।
11th, my lordship does not make it on 11th. 11th is having some problem, my lord. I'll not be in Calcutta, my lord. 11th. Any day, either before or after.
Let us come up with written notes of argument and finish
My
it
lord,
off.
let me first find out whether your lordship will discharge the receiver or not after hearing me.
তাহলে তুমি একটা কাজ বাকিগুলো কত দুটো 4th এ চলে গেছে? Why, what is the difficulty on 11th?
Well, I'll not be in Calcutta, man. That's the problem, man. 11th.
You don't need বাবা।
Man, you also can keep it next week also, next Thursday also.
ঠিক আছে, 4th এ রেখে দাও। 4th.
My lord, let it be a peremptory adjournment, my lord. Because too many times we have come up and we have gone back, my lord. And my lord may also direct filing of written notes, my lord.
Parties are at liberty to file written notes of argument on the returnable date. Please remember the 4th. 4th.
I'm extremely grateful to my lord.
Huh? Is this matter on 4th? Next time, make it short.
I'll make it extremely short, my lord. I'm grateful to my lord.
Item number 3.
My lord, I beg to appear for the caveators led by learned advocate Udaran Betal. My lord, he is not come to the duties, personal difficulty. Only praying, only not today, my lord.
I am for the petitioner, lordship. The petition is 80 years old. So a lot of times the matter has been heard. Our argument is over. Their argument is left. So if your lordship pleases, can the matter be kept next week at the top of the list so that it can be heard and disposed of? Because every Thursday it is appearing on the list.
Only Thursday I'm taking up the original.
I know.
If one day goes means entire week goes.
Exactly, your lordship.
Fourth আপনি কি করে হবে? এটাকে 11th দাও। এটাকে অ্যাটলিস্ট 11th দাও। নেক্সট উইকে দিও না। 11th কি আছে দেখো তো? ফাঁকা আছে? 11th টপে দিয়ে দাও। প্রথমে এটাকে নিয়ে এসো। 11th you conclude? Accommodation is sought for on behalf of Mr. Uday Narayan Betal, learned advocate for the respondent. Is this matter 11th September?
Time.
11th.
Sorry, I could not make it for the previous matter.
Okay.
Should I appear for the petitioner in this?
My lord, I am appearing for the respondent number 1. My lord, I have an application
I am appearing 7, my lord.
of the petition under Order 7, Rule 11, and they had filed an opposition. However, we have not yet filed the affidavit in reply. I am seeking 2 weeks time extension to file the affidavit in reply. Thereafter, the matter can be kept for hearing of the.
No, ये application টা কোথায়? GA যেটা এই ফাইল করে rejection of
My lord, the 28th November order records that the GA1 affidavit directions were given. Confusion.
But you're sure enough to ask him to junior to get what?
21st?
28th November, my lord. But however, the opposition was filed on a belated date, not within the time frame. We are seeking 2 weeks time to file the affidavit in reply to that, and thereafter the matter can be kept for hearing, my lord. I am being led by Mr. Anil Bande.
Lordship, I'm praying that this matter be fixed after vacation, Your Lordship. We can take their time, Your Lordship, to file the reply.
Advocate for the you are for respond number?
My lord, I am for respondent number 1.
Respond number
Deepak
1.
Adhikari.
I am for 7, my lord.
Respond number 1. 6. Extension of time to file affidavit in reply. Okay. To the affidavit in opposition filed by
Petitioner.
applicant in GA 1 of 2024. Within a period of which? How long
Lordship,
you will
the
take?
GA has been,
2 weeks.
2 weeks.
Lordship, may I? The GA has been filed by the respondent number 1, Your Lordship. He's the applicant.
This is rejection of you. You are the applicant.
I am the petitioner, Your Lordship. So I filed my affidavit in opposition to his GA, Your Lordship. Now he will file the reply to that.
2 weeks for ago. Let such affidavit in reply be filed by the applicant in GA 1 of 2024 within a period of 2 weeks. সপ্তাহ পর 11th এখানে 2 সপ্তাহ
Lordship, fixing it after the vacation.
on 11th.
Sir, I think they are praying that the matter be fixed
After the vacation, Lordship.
With permission of the let it be after vacation. Let it not.
Both the on the joint prayer of the parties, list this matter on vacation 6th November.
Grateful.
I'm grateful to Your Lordship.
My name be kindly recorded, my lord. For
Yes.
7, my lord.
Onuron Samanto.
I'm grateful, my lord.
Samanto in virtual mode. Learned advocate for respond number 7.
I'm grateful, my lord.
Onuron Samanto.
Lordship, I'm appearing on behalf of the petitioner, Your Lordship. Lordship, I'm appearing on behalf of the petitioner. Lordship, the contempt proceeding arises out of violation of an order dated 15 January 2025 passed by your Lordship. Lordship, if I may be allowed to give just a bit of factual background. The disputes between the parties have arisen on account of the requisition of the petitioner's flat for the purposes of the Home Department, your Lordship. There has been a series of litigations in this matter, in which finally in this writ petition, a special referee was appointed to quantify the total amount payable to the petitioner on account of arrears of rent and mean profit. Now, special officer has filed a report, your Lordship, and on that basis, Lordship had been pleased to pass this order of 15 January 2025. Now, Lordship had directed them to pay a certain amount on account of principal along with interest, your Lordship. Now, within 2 months from the date of the receipt of order, we have filed this contempt proceeding because 2 months had passed and they did not pay any amount. Now, Lordship, after filing of this contempt proceeding, there has been subsequent developments. We receive a letter of 18th of July, which is at page 54, your Lordship, whereby we were called by the contemner and we were told that we are paying such and such amount to you. Lordship will find the check at page 55 and Lordship will also find a calculation at page 56. Lordship will find that they have given us a sum of rupees 16,34,162 on account of principal and interest at the rate of 8%. Lordship, they have paid 7,73,000. So therefore, the gross amount comes to 24,07,000 and odd. Now, Lordship kindly takes up your Lordship's order of January 25. Lordship will find that at page 17 of my application. Lordship, I will not trouble your Lordship with the entire order. Please, Lordship kindly comes to page 20. Lordship, page 20, the third paragraph.
Lordship, when did the dues accrue?
Lordship, that is the point, your Lordship. This flat was requisitioned in the year 1970, your Lordship. The area rent has fallen due from the year 1975. So therefore, your Lordship, this interest have fallen due from the dates of the...
What was the amount of rupees that it is from the petition intention to together?
Lordship, the dates on which each of the amounts have fallen due. We have shown the quantification.
What was for the state
Lordship,
in the original proceedings?
Mr. Tonoy Ganguly, Mr. Tonoy Chakraborty was appearing, and Mr. Siddiqui was also appearing at one point of time, Lordship.
Okay.
Now, Lordship, we have given a calculation, Lordship. According to us, the amount that is payable on account of interest is 34 lakhs 4,000 and odd. Out of
7 lakhs. Huh?
Out of which, yes, your Lordship, they have paid 7,73,000 and odd.
This you have received.
Yes, your Lordship. We have received the principal amount of 16,34,000 and a sum of rupees 7,73,000 on account of interest.
From 1975 till 7th April 2019.
Yes, your Lordship. Lordship, according to our calculation, we have given a detailed calculation. The total amount payable to us is 34 lakhs and out of which 7 lakhs have been paid. So therefore, 20...
Ashun.
Lordship, 26 lakhs and odd is payable.
To the who is the alleged contemner?
Lordship, the alleged contemner is the land acquisition collector, Mr. Oghor Kumar Roy.
Give him a notice.
Yes, your Lordship.
This is an application for contempt. Mr. Wensul, an advocate for the applicant, submits that by order dated 15 January 2025, the respondent number 2, first land acquisition collector, Kolkata, who is alleged contemner in the present application, was directed to disburse an amount of rupees 1,634,162 together with interest at the rate of 8% per annum from the date of accrual of the dues till the date of actual payment in favor of the petitioner within a period of 2 months from date of communication of the order. The alleged contemner has paid an amount of rupees 1634,162, which is the principal amount. Yet the interest has been calculated from 8th April 2019 to 7th March 2025, which ought to have been from
the date of accrual, Lordship, right from 1975.
From the year 1975.
Lordship, whenever each component of payment has fallen due, we have shown a detailed calculation also.
Advocate for the applicant is directed to serve notice upon the alleged contemner, namely First Land Acquisition Collector, Kolkata, and file an affidavit of service on the returnable date. When can this be completed? 2 weeks পরে সেই 4th September হয়ে যাচ্ছে 4th September. We রাখবো এটা September 4th September.
Lordship, may I just clarify one thing? I filed a separate application in the main contempt proceeding. There is a contempt application, and I have also filed a GA, Your Lordship, GA number 1. Lordship, because Lordship, I have brought in the subsequent facts by way of the GA application.
Hello, with করে দিন contempt application with GA. Then you serve both the applications.
Yes.
What is both the applications? GA 1 of 2025 with করে দিও পরে cause title contempt with GA this. Right.
I'm grateful, Your Lordship.
My lord, I'm for the petitioner. I'm for the petitioner in GS6 and respondent in GF5, my lord.
But I was submitting on the last day, my lord.
In GA5.
In GA. But in fact, the issues are, my lord, really overlapping because, my lord, one is our application for extension of time to lodge to lodge the caveat and for filing affidavit in support of caveat. And the GA6 is, my lord, the propounder's application for, my lord, discharge of the caveat. My lord, will kindly have a look at chapter 35 of the original side rules. My lord, I was making submissions on that on the last occasion.
Original side rules? Chapter 35.
Chapter 35. This pertains to testamentary and intestate jurisdiction.
Rule 9.
My lord, will kindly have a look at Rule 9. Ours is a letter of administration because there is no will. On an application for letters of administration, unless otherwise ordered, a citation shall issue to all persons having a right to take the grant prior or equal to that of the applicant unless such persons have signified their consent to the application. Two things emanate from this. A, that in case of a application for letter of administration, a citation has to be issued. But the departure is unless otherwise ordered. But here there is no order to the contrary that citation need not be issued or for any other reason it is waived or anything of that. So there is nothing to the contrary. Now, if my lord kindly sees, the next portion is that unless such persons have signified their consent to the application, there is no consent either. So, my lord, this is a case where citation had to be issued. Now, my lord, it was submitted by my learned friend that there is no requirement of a citation, and he submitted on the what is an objective of a citation to inform with regard to a proceeding. That is the objective of a citation. But I do not join issues with that. But the only difference, which I may humbly try and draw your lordship's attention to is, your lordship would knows, a citation can be a general citation also, which is like a publication in a newspaper. Special citation is when the cost papers of the probate or letter of administration is sent to a particular person. But general citation is on a paper, notice board of the High Court. These are the general citations. So, just by citations, one cannot contend that one has to file a caveat and an affidavit in support of caveat. There is something more to it than what is required to be done than what is being submitted by the petition. Why I say so? Kindly takes a look at Rule 24. This is caveat. Any person intending to oppose the issuing of a grant of probate or letter of administration must either personally or by his advocate acting on the original side file a caveat in the registry in form number 12. Notice of the filing of the caveat shall be given by the registrar to the petitioner on such and such. So, my lord, what happens when one comes to know of a proceeding, one lodges a caveat. Maybe from a citation, maybe from something else, a caveat can be lodged. Now, my lord, in this case, there was no citation. Till date, no citation. What is there is the PLA was filed. In connection with the PLA, immediately along with filing of that, possibly, they have taken out a GA for certain interim reliefs regarding operation of bank accounts and all. So when we were served with the GLA, we lodged the caveat. Now, in all these years, till today, the PLA has not been served on me. Till today. Despite my application being there, please give a copy, nothing has been given. It has been submitted by my learned friend.
Tell me one thing, just not on the original side, on the civil civil procedure code. If there is a suit and the defendant quo enters appearance, will the time to file the written statement will commence from the date of appearance, or again one has to seek whether the writ of summons has been served?
Well, summons has to be served unless the summons is waived by the defendant. But in lot of situations, even in our High Court, procedure of service of the summons is same as High Court or any other court. Even in our High Court, when the defendant appears, we normally say that, would you waive the service of summons? Then your lordships have always recorded an order that service of summons is waived, then from that date the time commences. But because I'm contesting an interlocutory proceeding, my time to file written statement would only commence when I'm served with the summons, because summons would have the plaint. So, in order
presumption of service,
there is no presumption. They have said that they have not served. So here also the presumption is not there. What their contention was, PLA and G are identical almost. I do not know. If I have not seen the other, how would I know it's identical? Maybe they have claimed something more. So I do not know.
Okay.
Now, if you what my learned friend was trying to get into this matter through a mischief, which is there in Rule 25. But I would humbly beseech that your lordship would read down the statute or read down the provision to mean, which I'll just explain in a bit. Kindly see Rule 25. Affidavit in support of caveat. Where a caveat is entered after an application has been made for grant of probate or letters of administration, with or without will annexed. And may I pause here for a moment with my lord's kind indulgence. Ours is a case where a caveat is entered after an application has been made for grant of probate. But why? Because in point of time, it was after the grant application was filed. Though I was not served, but it was after the filing of. Then kindly see the affidavit or affidavits in support of caveat shall be filed within 8 days of the caveat being lodged, notwithstanding the long vacation. such affidavit shall state the right and interest of caveator and the grounds of objections to the application. Kindly marks this. So what my affidavit has to state, the rights and interest of the caveator and the grounds of objections to the application. So this, my lord, in my humble submission, your lordship would read the service into this. Because if the application is not served, to what would I use the affidavit in support of caveat to object the grounds of objections to the application? I have not been served the application. So what they are trying to come in is within the first part of Rule 25. That see, caveat is lodged after filing of application for probate. So you have not filed within 8 days, right closed. Sum and substance of his argument. Nothing else. This is his whole argument. Application filed, caveat filed thereafter, affidavit in support of caveat not filed, caveat should be discharged. But to what should I file? So my lord, herein comes the issue that I have to file objecting the grounds of the taking the grounds of objection to the application. Then my lord will kindly see they are now coming within reading 25 with 27. Consequences of not filing caveat. While the caveator fails to file any affidavit in support of caveat in compliance with Rule 25, on accordance with compliance with rule notice issued under Rule 26, the caveat may be discharged by an order to be obtained on summons. Again, it's not an absolute thing, it may be discharged. So that the discretion is there, may be discharged. Now kindly sees why this assumes importance, that the application for grant of probate or letter of administration has to be served. Why I am emphasizing on this, apart from the last line of Rule 25, kindly sees Rule 28. Procedure on affidavit being filed. Upon the affidavit in support of caveat being filed, notice thereof shall immediately be given by the caveator to the petitioner. The proceeding shall, by an order of a judge upon an application by summons, to be numbered as a suit in which the petitioner for probate or letter of administration shall be the plaintiff and the caveator shall be the defendant. Kindly marks the next expression. The petition for probate or letter of administration being registered as and deemed a plaint filed against the caveator, and the affidavit filed by the caveator being treated as his written statement in the suit. So I have to contest the proceeding by filing my written statement without looking at the plaint, without being served with the plaint. This is what the submission leads to of my learned friend. Yes. I have to file the written statement, but I will not get the plaint. But it may so happen that sometimes somebody lodges a caveat in a normal caveat. I'm not saying in a probate or testamentary matters. Somebody is on caveat, one appears in court, then your lordship directs, please serve him copy of the application. But that would not absorb the duty of the plaintiff to serve the summons on him. Summons is something else. That is the plaint. Yes. But we contest interlocutory applications for several years. But the time limit to file the written statement is prescribed by the statute from the date of receipt of the summons. Well, that is why your lordship would kindly see my prayers in GA5. Kindly takes a look at my master summons, which I have taken out.
ये 5 में master summons to them. ये 5 है. Yes.
Kindly sees my prayers, and I've consciously made this prayers. An order be passed directing Mrs. Rama Sen, that is the propounder, to serve a copy of PLA such and such on the applicants. I have not received a copy. Leave be granted to the applicants to file caveats. There can be different caveats, several caveats. The judgments are there, I shall show. Then, my lord, leave be granted to file affidavit in support of caveat within time. So, my lord, unless I get the application, I cannot file any affidavit in support of caveat. To which would I reply? To what? What would I deny? What would I try and contradict, my lord, if I don't see that? That is the entire thing. Now, there is really no direct judgment on this proposition that whether this has to be served or not served. Either way, I have not found any. I don't know whether my learned friend has found. In fact, he has not cited any judgments on that also, that application need not be served. One can file affidavit in support of caveat without the affidavit. But this is all which I could lay my hands on. Kindly see, there's a coordinate bench judgment. The application for discharge of caveat and the application for extension of time to file affidavit in support of caveat are taken up for hearing and disposed of by this common order. Identical situation as ours. Identical. The caveatrix lodged caveat on such and such. The caveatrix has taken a plea that since she was not served with a notice of the caveat, in terms of Rule 26 of Chapter 35, the time to file affidavit in support of caveat would not arise. However, she has taken out an application for extension of time to file the affidavit in support of caveat in view of the fact that the executor in the application for discharge of the caveat has stated that on such and such the general citation was issued, and on such and such the clerk of Victor Moses and Company has accepted the notice on behalf of the caveatrix. But no affidavit in support of the caveat has been filed within the prescribed period. The caveatrix would contend that the service of the notice upon the advocate on record of the caveatrix would not satisfy the requirement of Rule 26, and accordingly her time to file affidavit in support of caveat cannot be counted and or reckoned with from that date. Mr. Such and such learned counsel appearing on behalf of the executor submits that while the caveatrix had taken a plea in the affidavit in opposition that she could not file affidavit in support of caveat, as no notice of the caveat was served on her. However, in paragraph 8 of the affidavit in support of summons for extension of time to file affidavit in support of caveat, it is stated that a notice of filing the probate petition was sought to be served upon the advocate on record of the caveatrix through an office clerk, but no copy of the probate petition or, kindly marks, no copy of the probate petition or the notice thereof was served upon her. Due to sudden illness of the said court clerk from the evening of January 10, 2014 till about February 10, 2014, the caveatrix was not intimated about the such service of notice. As a result thereof, she could not file affidavit in support of the case. The said affidavit was affirmed by the caveatrix on such and such. Then, my lord, this Nandalal said judgment was relied upon in the next paragraph, and submits that the said decision is an authority for the proposition that no notice is required to be served on the caveator under caveatrix, and the service of notice upon the advocate on record of the caveator or caveatrix is sufficient service. The plea taken by the caveatrix that she could not ignore service on the advocate, I am not troubling your lordship with this, my lord, kindly then turns over to the next paragraph. Under such circumstances, I am inclined to give an opportunity to the caveatrix to file an affidavit in support of the caveat. Since the department has also not served the copy of the application for grant of probate, and the caveatrix could not file the affidavit in support of the caveat, the executor shall serve a copy of the application for grant of probate upon the advocate on record of the caveatrix within a week from date. The caveatrix shall file an affidavit of the caveat within a period of 2 weeks from the date of service of the probate application. So, here, not identical facts, but somewhat similar facts, where since this copy of the application for grant of probate was not served, that was directed to be served by the propounder on the caveatrix, and the caveatrix was thereafter directed to file the application. No matter why this judgment is a little departure from our case, that I should also point out. This judgment is possibly from whatever is being submitted is relying on Rule 26. Correct. Rule 26, if my lord kindly takes a look at. Here, my lord, this Rule 26 is applicable when an application for probate or letter of administration is filed after the caveat is lodged. So caveat can be lodged before, caveat can be lodged after. So this judgment was really dealing with a Rule 26 situation. But I was only relying upon this for the ratio that, since the department has not served that, the time did not commence, and this time did not run. Just overhearing my learned friend, he says that it does not envy such service. Rule 25
No, I did
last
not say
line.
that. Mr. Dutta, I did not say that. I did not say
Anyways, but Rule 25 last line would show that the grounds of objections to the application is what my affidavit should contain. So that would necessarily imply that the service of the application is a sine qua non to my filing the affidavit. Otherwise, I cannot file an affidavit if I do not get the application. So this judgment somewhat deals with the issue, not exactly on my point, but somewhat deals with my issue. That's one other judgment I should cover your lordship with, and then I'll conclude.
Yes.
No, no other judgments, Manoj. Manoj will kindly take a look at my application once. Just 2 or 3 paragraphs I'll indicate to your lordship and I'll conclude. Paragraph 2 and 3 at page 2, that when I had received a copy of the GA, in connection with that, though no copy of PLA was served, I had coming to know from GA that a PLA was filed, I lodged the caveat. That is paragraphs 2 and 3. Then paragraph 4. Till date, no citation served on the daughter. Daughter has not filed any caveat. Daughter has not been cited till date. And paragraph 8 at page 3, Malud, that till date I have not received PLA. So, Malud, the entire sum and substance of the submission of my learned friend is that the rules, the original side rules, or this chapter in particular, does not show requirement of service of the PLA on the caveator. Nowhere in the rules it says that it has to be served if a caveat is lodged after the citation.
Yes.
That is the contention. But I would humbly say, because of the language of Rule 25 and 28, that has to be read into. Your lordship's endeavors have always been to harmoniously construct statutes to make it workable. But here your lordship would find that unless this is done, I cannot file a written statement because the PLA would be the plaint, affidavit would be the written statement. So when it's service, though not specifically spelled out, has to be read into it because citations can be general citations also. This does not, my lord, distinguish with regard to, my lord, a general and a special citation. Special citation is somebody being cited. And also citations, as per the original side rules, does not require a PLA to be attached to that. So, my lord, citations really doesn't mean anything. Receiving a citations is not equated with receiving a summons. Because with the summons, plaint is annexed, that is the provision of the CPC, which says plaint has to be annexed with the writ of summons. But citations does not specifically spell out that the application has to be attached to that. So whenever a citation is received, one lodges a caveat. Then it is the duty to give that copy so that I can file my affidavit. This portion is not there spelled out clearly. But the provisions would show that that has to be read into it. These are my submissions. But if you, in fact, I am told by my learned advocate on record that when special citations are served, normally the petition with the consent affidavits, everything are served, but the rules are silent on that also. And before I conclude, one other thing I should indicate that we have also filed an application for letter of administration. We are in the process of having that assigned before your lordship because your lordship is hearing the matter. So that
when did you file that?
We have PLA 238 of 2025. That we have also filed. Apart from this also, we have written a letter to the registrar so that we can have it assigned before your lordship because your lordship is hearing up this matter as a specially assigned.
This is perhaps at a counterblast to my argument that they have no competing claim. I'll explain in the next. Because they did not. This PLA was, this application is being argued for last 3 years. So this 2025. I will explain. আমি জানি কিন্তু আমাদের জিএটা কথা বলছি।
Alright, Mr. John Gupta, London advocate for the respondent. এটা 5 and 8 করে দিও, হ্যাঁ 5 and 6 টা দাও, 6 টা করবো। For the applicant in GA5 of 2023 and respondent in GA6 of 2023. He concludes his argument.
Lordship takes it up next week. I will just rebut.
Next week কি অবস্থা? ওটার উপরে দিয়ে দাও। So হয়ে গেছে।
I will not take more than 15-20 minutes.
Completed. Kumarjit Banerjee, London advocate for the applicant in GA6 of 2023 and respondent in GA5 of 2023 seeks to make his replies. List this matter on 26. Make his replies. 28.
I'm so good.
Keep your pledge.
Yes. Chamber এসো। Chamber এসো বলে দাও। চলো। Take your book. This is your book.